Well, good afternoon and welcome to Comedian of Law's Deal or No Deal. Hope you're enjoying this fine Friday afternoon. I am doing this from Kansas City, but I got to tell you, my heart is in Nebraska. I am eagerly looking forward to this upcoming football season, trying to score some tickets. I am a big Nebraska fan. I actually have a lot of heritage from Nebraska. My grandmother lived to be 101 years old up from Gordon, Nebraska. And so whenever I get to talk to people from the great state of Nebraska, I get all excited because, well, it's football season coming on. Well, I do want to apologize to those of you who thought there's a misprint in the promotional material. I got to tell you, it happens every time I talk. I've been doing this for 4 years now. It still happens every time I talk. Every time I go to an airport ticket counter, someone was confused. You read that name, thought, wow, I can't believe they got Joel Osteen to come teach CLE. No, I am not Joel Osteen. I am Joel Oster, but nonetheless, some of you were confused. It happens every time I speak. So if you were confused, let me help set the record straight. You see, there is Joel Osteen. Yes, he a nice pearly whites there. Whoever his dentist is, I gotta get the name of that guy's dentist. He could do some product endorsement there for teeth whitening. Nonetheless, he wrote the best-selling book, Your Best Life Now. Now that makes sense, right? I mean, after all, he is a pastor. He is connected to the Almighty. It makes sense. He knows something about living your best life now. But come on. I'm an attorney. No one is going to an attorney trying to get tips on living your best life, right? It's called Subpoena Me Now, not Serenity Now. But nonetheless, all is not lost. You see, I can still help you out. I have my best-selling book, which is called Who to Sue If You've Been Screwed Out of Your Best Life Now. It's a little difference between Joel Oster and Joel Osteen. Well, it is good to be with you today. And I do practice in constitutional law. I've had a couple cases go up to the U.S. Supreme Court that I was lead on. One pretty recently, and I got to tell you, I was a little nervous this second time around because the first time my arguments were presented to the U.S. Supreme Court, well, let's just say they were not too enamored by my argument style. Here's an actual photograph of the justices during the argument, and so yeah, they weren't exactly enthralled by the argument style. No, of course, I assume you know the context of that picture. That was taken from the State of the Union address a few years back, and in her own words, Notorious RBG's own words, she said, "I wasn't entirely sober." Apparently what had happened is Justice Kennedy brought over some wine to the pre-State of the Union address meal. Now I had no idea that they tailgate before the State of the Union addresses, but hey, they're in D.C. They do things a little bit differently there than they do in great state of Nebraska, but I do love the look on Justice Kagan's face, right? Come on, somebody wake Grandma up. Someone give her the elbow nudge. Wake her up. Well, nonetheless, I cannot judge. She's had 2 bouts with stage 4 cancer and hardly even missed a day at work. Had a heart stent put in recently as well. But nonetheless, we are going to today play a game called Deal or No Deal. Now, I normally do this in my live class by throwing out candy bars to people who participate. I can't quite throw them there to you, but nonetheless, we're going to do this, and you can respond if you like to in the comments, or just do it in your head, whatever. But I am going to give you a factual scenario, and it's going to relate to an ethical violation, ethically challenged attorney somewhere did. And then we're going to have to analyze the rules that are at play, the severity of the facts, and kind of mitigating circumstances. And then I'm going to give you a deal. Would you take this deal for that ethical violation? So again, toss that in your head. Answer via the comment section if you would like, or just think about the thought through, and after we toss it around for a bit, I'll give the actual outcome of that case. All right, let's start off here with my newfound favorite case. I just discovered this case recently, and now I'm going to lead off every single class I ever teach with this case. It is a great one. In Ray Hartke. Here's what happened here. This attorney went to a CLE. Now, this didn't happen during my class, thank goodness, but he went to a CLE and he fell asleep. I'm reading straight from the court's order here. He fell asleep and began snoring during the seminars, during the presentation. All right, now I really hope that has never happened in my class. What do you do if you got someone snoring in the middle of your CLE? Well, that afternoon, he then began talking loudly as the presentation was going on as well. That did happen in one of my classes. I was teaching a class, and all of a sudden a gentleman took a call during the middle of class and was a very loud talker, and just engaged in that phone conversation out loud while everyone was there in class just kind of staring at him, staring at me, saying, what are you going to do about this? It's kind of awkward when someone takes a phone call in the middle of a class and then talks loudly and doesn't even bother to move. But nonetheless, that is what this attorney did here. He fell asleep, began snoring, and then in that afternoon, someone smelled some alcohol on his breath. All right, now I think we're getting to the bottom of this here. Smelled some alcohol on his breath. And so investigation was commenced against this attorney for sleeping during the CLE. Well, he did not want to own up to it, and he denied snoring. Now, isn't it just like a snore? I got to tell you, whenever I am accused of snoring, the first thing I say is, no, there's no way I wasn't snoring, turn over, things like that. Well, nonetheless, he denied it. He denied the alcohol, and then an investigation again was commenced. Now, he was busted for what he did here, but I got to tell you, the reason why he was busted disappointed me just a bit. I think that this court had a chance to really kind of move the ball forward and set some great precedent for all CLE instructors everywhere, but nonetheless, they didn't. Under Rule 8.1, you have to cooperate in the investigative procedures, and if there's a misstatement that's out there in your disciplinary matter, you have an obligation to correct that, and he did not do that. And so here's what the court ruled. The court said that Mr. Harkey was not suspended for sleeping and snoring. I gotta say, the court punted on that one. I really wish they had held otherwise, but nonetheless, the court said rather he was suspended for failing to correct misrepresentations that he made to the Virginia State Bar in the course of the Virginia disciplinary proceeding. And so there you go. Do not snore during this class. Well, nonetheless, the deal I'm going to offer you here is a complete and total banishment from all things law-related, the apocalyptic disbarment. Would you take that as a punishment for your for this violation of the rules? Well, you got to consider it. I mean, of course, I'm just being a little facetious here. I do think this is the punishment I would like for them to dole out for sleeping during a CLE class. But nonetheless, the actual outcome was a 6-month suspension. Still, does that scare any of you? Sleeping through a CLE landed this guy a 6-month suspension from the practice of law. Well, I guess he'll have plenty of chances now to catch up on his rest as he thinks about what he did. So there you go. That is my new favorite case to start out all future CLE classes. All right. By the way, another thing I want to do as we go through today's class, a new thing that I am working on is you might be trying to get a new lawyer, and so these are kind of like in the Jeff Foxworthy genre, if you can think about it. And so here's my first. It might be time to get a new lawyer bit. And how about this? If your lawyer brings a pillow with him to his continuing legal education class, it might be time to get a new lawyer. And so I'm going to have several of these as we go through today's class, but I do want to hear from you. If an idea comes to your mind of an example or a situation where it might be time to get a new lawyer, let us know. Also on my Facebook page, Comedian of Law, we have a Facebook page. You can go to our website, comedianoflaw.com. That will take you to our Facebook page as well. I want to hear from you as to things that you think might be a great time, great situation to revisit your lawyering needs. So, all right, well, let's go move on here to our next deal or no deal. And now we're going to go to Mesa, Arizona. And this attorney did, well, quite frankly, I think if we were all honest, we all fantasize about doing. I know I have fantasized about doing this. I mean, what this attorney did. In fact, I have a client right now who text messaged me on my cell phone. I got the message, and I got to tell you, yeah, I want to do this. He apparently did a Google legal search and thinks his Google legal search supersedes my actual law knowledge. And so let's see what this one Mesa attorney did.
After this shocking video, a Mesa attorney striking his client across the face. Remember this video? Tonight we're finally learning how he'll be punished.
ABC 15's Nick Saletti on this case for a year now. And Nick, what are you finding out?
There you go. Did I not mislead you? Have you not fantasized about doing that very thing? Slapping your client? I mean, sometimes they love to do their own Google legal research, play a lawyer, whatever, discount your 25 years of experience and expertise in this matter for their own thoughts. But nonetheless, I surely hope none of you have lived out that fantasy. Under Rule 8.4, we are required to act as professionals. We cannot act in ways that cast doubt as to our fitness to be upstanding, honest lawyer. And yeah, surely slapping your client while the videotape is running is not a very good idea. That's what this Mesa attorney did. And so the deal I'm going to offer you is a 90-day suspension. Would you take a 90-day suspension for slapping your client? Now, I want to make sure we're on the same page here. I'm not saying, would you slap your client for a 90-day suspension? Yeah, I know several of you are looking through your contacts list right now saying, okay, yeah, this guy I would, this person I definitely would. So no, that's not what I'm asking here. I'm just saying if you did that, it is a violation of Rule 8.4, and as punishment, would you accept this deal? Well, let's hear the actual outcome of the case.
A formal reprimand and 2 years probation. That is the punishment the State Bar Association is handing down to this attorney you see here, getting up and slapping his client across the face. He was behind bars at the time, handcuffed, unable to defend himself. Tonight, I spoke with that man's family, and they tell me that punishment doesn't go far enough.
He assaulted a 54-year-old cardio patient. Are you kidding me?
But there was no joking around in this video.
I was hurt. I saw stars.
Last July, we spoke exclusively with Michael Moore, an inmate at the Florence prison. In March of 2016, surveillance cameras at the Durango jail captured this altercation between Moore and his former defense attorney, Kent Nicholas. After a heated back and forth, you see Nicholas get up, take that stack of papers, and slap Moore across the face.
I couldn't believe that, number one, he talked to me like that, and number two, that he assaulted me.
More than a year later, we now know Nicholas is facing a formal reprimand and 2 years of probation from the state bar, but will not be suspended or disbarred.
The punishment is just a slap on the hand.
Moore's cousin, Stephen Marachnik, doesn't think that's enough. In addition, Marachnik claims he's paid Nicholas $4,300 and wants every last penny back.
I didn't pay him all this money to beat up on my cousin.
I spoke with Mr. Nicholas's attorney, brought up these claims. Unfortunately, he was not able to comment on this case. Now, the judge still needs to formally sign off on the punishment, but we know both sides have agreed to the terms. Reporting here in the newsroom tonight, Nick's.
All right, so the actual outcome was a public reprimand and a 2 years probation. So if you turn down that deal, good call on that one, as he did receive a slightly lighter sentence, but nonetheless, the takeaway from this is, yeah, that's not professional, that's not okay. I do not want you thinking, okay, you know what, I think I might slap some clients now if I know it's only going to be a public reprimand. Surely that's worth it in a couple of these situations. No, that's not the takeaway from here. It is a violation of Rule 8.4. All right, this next case. Oh, so it's time for our next. It might be time to get a new lawyer quote here. And so if your lawyer's hearing and your hearing are on the same day, it might be time to get a new lawyer. And so, yeah, you don't want to coordinate schedules between your hearing and your client's hearing. That's not going to be a good scenario for you. All right. Well, by the way, it's not always the client who has to be, aware of his surroundings. Sometimes the attorney, well, you gotta be cognizant of where that stiff right hook might be coming from, as this one Kentucky attorney found out the hard way.
Lawyers are about as popular as Darth Vader and the tax collector, but no matter what you think about him, he had to feel awful for that attorney who got knocked out cold by his own client in a Kentucky courtroom this week. Well, the good news is public defender Doug Krigmer is out of the hospital, and he's back at the very courtroom where it all happened for us this morning. Doug, good morning to you.
Good morning, Meredith. How are you?
I'm probably better than you. I'm glad you're back at work, but boy, it's apparent you took a pounding there. What's the extent of the injuries? I can see the big black eye, obviously.
I've had some bruising in the face, some swelling. I had a cut on my cheek. They took me to the hospital after it occurred. Ran a CT scan, checked me over, and came out okay.
So, Doug, take me back to Monday and tell me what happened. You're with your client, Peter Hafer, okay? He's going on trial for burglarizing a Kmart last summer. What made him go punch you? This is a pretrial hearing.
Well, he definitely one-shotted me, that's for sure. We were having the hearing. I should state, as a public defender, a majority of my clients are mentally ill or have a mental illness. Mr. Hafer's case, and I certainly don't fault him or blame him or wish him any ill will. Mr. Hafer had been in jail for some time. He's looking at some significant jail time if he's convicted. He's got some new charges coming at him. He's got some anger management issues.
I'd say yes.
No, he should have just stopped while he was ahead. Now, I understand why he accepted that interview opportunity. It's not every day that you get a chance to talk to the national media. But, under Rule 1.6, as attorneys, we are prohibited from telling third parties things that we learned during the course of a representation without the client's consent. That's called the attorney-client confidentiality rule. And yet, what did he just do? He told a national audience on whatever that was, ABC News, that, my client, he's a little bit crazy, a little bit loco. He's a little bit deficient between the ears. Not a very wise thing to say about your client to a national audience. That would be a violation of Rule 1.6. Also said his client had some anger management issues. Though the cat might have been out of the bag on that one. I'm thinking we pretty much saw that one on full display there in court that day. Nonetheless, was he disciplined for violating Rule 1.6? No, maybe the Kentucky bar thought he already received his punishment in full. I don't know, but no further punishment for this poor attorney. By the way, one of the things I absolutely love about this video is the reaction of the guy sitting there at counsel's table. You see him right there? Watch his reaction to what is going on in front of him.
Mr. Hafer had been in jail for some time. He's looking at some significant jail time if he's convicted. He's got some new charges coming at him. He's got some anger management issues.
I'd say he has definite anger management.
What was so important on that paper that he couldn't even bother to look up? I have no idea, but nonetheless, it was a violation of Rule 1.6. All right, moving on to our next deal or no deal. This is a recent case from this last year. This is in Ray Quitshaw. I'm not sure I'm pronouncing that correctly, but there you go. And so the facts of this one, well, you're really not going to believe these facts. I mean, again, they say that truth is stranger than fiction. You could not make up these facts in this case. In fact, we blogged about this on our blog. It was an amazing case. But nonetheless, here's what happened. He had this attorney, and he regularly he was a divorce attorney and regularly appeared opposite this other attorney, a female attorney, and divorced quite a bit. I mean, they were in a local small county there, I guess, and this was done in, it looks like in Illinois. And so they often, went up against each other in court. Well, apparently this guy, Mr. Quitshaw, he was not too happy with this. Maybe she always got the better of the deal. I don't know. But he wanted revenge against his opposing counsel. And so this is what he did. I'm just going to read to you from the court's order because I could not do it justice. So here you go. And it says he went and basically created a fake profile on Match.com for this opposing counsel. Yes, he went to a dating site and set up a fake profile of his opposing counsel, picture and all. And this is what he said about the kind of person that she is and the kind of person she is seeking. All right. And so that Mosby Scott was separated from her husband. Again, not true. Her children sometimes live with her. try all the time to live with her. She smokes but is trying to quit. She regularly drinks alcohol. She is an agnostic. She is 56 years of age. She does not exercise and enjoys auto racing and motocross. She has cats, and her favorite hotspots are, again, I cannot make this up. Her favorite hotspots are the grocery store, all restaurants, the pizza ranch, all buffets, and NASCAR. And so, yeah, I'm assuming that's probably not a regular descriptor on dating profiles for women, but nonetheless, that is what he did. He put all that on this fake dating profile on Match.com, I guess to embarrass her. I am not sure why he did that. With her picture, though, he had her picture and her name there. And so obviously all of those were false. Those were lying. She apparently does not like NASCAR or hates cats. I don't know. But nonetheless, it was all a lie. That wasn't the only thing that he did. In addition, what he did was he went to, let's find here the order. He went and signed her up, registered online, registered for this organization called Obesity Action Coalition, so that she would be a member of and receive materials from that organization. As someone who also is somewhat a weight vertically challenged, however you want to describe it. I had not passed through too many dessert trays in my life. That's probably a good idea for me to be a member of, but nonetheless, I kind of wonder, what is this guy doing? Has he lost it? Well, that's not all that he did. He then went and completed an online registration in this lady's name for an organization entitled Pig International. Apparently there's a group out there called Pig International. Now, as a person who had both sausage and ham with my eggs this morning, I have seen nothing wrong with pigs. I probably would enjoy being a member of that organization, but nonetheless, he is just simply, I think, losing control here. So he then went to a diabetic living organization, signed her up for that as well. But now I think he's just getting bored, right? I mean, the next one, he signed her up for Auto Trader. What is this guy doing? I mean, I can understand some of the earlier ones as far as being mean and trying to embarrass her. I don't know, but you sign someone up for Auto Trader? I think the guy is just simply getting bored at this point. And now some more serious things as well. Actually, these things have been serious, but nonetheless, he created a fake false review of her on martindale.com and also lawyers.com website, being critical of her legal abilities, and then also created a fake fictitious profile for the sole purpose of doing a negative review of her on Facebook. And so, yeah, this guy totally lost it. By the way, when she was interviewed afterwards as to her relationship with this guy, she said, "Oh, I liked him. He was a great guy. We got along together well." But apparently, in secret, this guy was doing quite something different. So that is what this guy did. Let me give you the offer here, a 90-day suspension from the practice of law. Would you do that? Well, again, what this rule requires, with the model rule 8.4 requires you to act in honest ways. You cannot engage in conduct, even outside of the courtroom in your legal practice, that casts doubt as to your ability to be an honest, fit, right attorney. Yeah, creating a fake profile, dating profile for opposing counsel, that's not kosher. That's not fitting the bill here for Rule 8.4. And in addition, during the investigative process, he lied about his efforts. She had to file a lawsuit against Match.com to get access to the IP address. It would turn out to be this person's law firm. And so they go to this law firm and they say, well, we're going to search through all of our computers. And lo and behold, of course, it was this guy that had done that. So would you take a 90-day suspension for that kind of those kind of shenanigans? Well, the actual outcome in the case was a 6-month suspension. Yes, he will have plenty of time. Now, this might not be a good situation, right? You're going to give this guy 6 months with nothing to do on his hands, but just think to himself, yeah, one wonders the trouble that he might be getting into down the road, but nonetheless, that is what the court ordered. All right, let's move on here now to our next deal or no deal. Now we're going to move over to the West, the great state of California. Now, if you are like a normal attorney, yes, I consider myself a normal attorney. Those people who are not like this are abnormal, but normal attorneys, when confronted with the opportunity for an extension of time or continuance, we love it. Whenever I'm writing a brief, I'm always saying under my breath, dang, I'd sure love to have an extra 2 weeks to work on this brief. Can we get a continuance? Can we get an extension of time? Most attorneys are like that. Yes, some attorneys don't ever want an extension of time. I have no idea how those guys operate in life. That is a life that I know not of. But nonetheless, here's what we do. We tend to get creative when it comes to describing the reason, the good cause for the continuance or the extension of time, right? And we harken back to our grade school creative writing days to see how can I, creatively describe this burdensome workload that's just going to scream, I need an extension of time in this matter. Well, I hope that we have never done what this attorney did in California, because he pulled the Fred Sanford. I don't know the ages of the attorneys that are taking this class today, but in my live class, whenever I say this, I notice that in the faces of the younger attorneys, they have no idea what I'm referring to when I say this person pulled the Fred Sanford. So for you younger attorneys out there who have no idea, this is the Fred Sanford.
Give me my money. No. I said no. No, I want my money. I said no. I got to get out of here. You went and did it. I might need that money tonight. I've never had pains like this before. Oh, this is the worst one I ever had, son. Oh, it's the worst one. This is the big one. I'm dying. You hear that, Elizabeth? I'm coming to join you, honey.
That's what he did. Every time that Lamont, his son there, said something he didn't like, then Fred Sanford pulled the fake heart attack. He put his fist to his chest. He grabbed and said, you hear that, Elizabeth? I'm dying. I'm coming to join you. Well, that's what this attorney did. This attorney really wanted to get out of trial in a bad way, and so he faked a heart attack to get out of trial. Unfortunately for this attorney, this court, was a very compassionate court, and this court was very sympathetic to this attorney's physical plight. And so this court said, wow, that's horrible. A heart attack by one of the attorneys who regularly appears before us? Wow, you know what? We should do something nice. Let's go visit him at the hospital. We can bring some cards, maybe some flowers, brighten his day. So the court wanted some specifics about this heart attack. All right, so right here, our attorney friend, he had some choices, right? He could have come clean. He could have said, oh, did I say heart attack? No, must have been autocorrect. You know how that dang autocorrect always changes everything. No, I had some Mexican food last night, had a little heartburn. That's all, just some heartburn. I'm gonna be okay. He could have come clean. He didn't. Instead, he decided to double down on his lie. Now, why do people do that? I have no idea. I have a teenage boy who loves to double down on his lie. It makes no sense, but that's what this attorney did. He offered specific details about this non-existent heart attack. Oh, yeah, I'm staying in the research hospital. I'm in room 101. I'm looking out the window right now. It's a nice sunny day out. Yes, the Dr. Anderson took care of me. Did an angioplasty. Now, folks, I don't even know what an angioplasty is. This guy is mentioning specific terms that he had done for his heart procedure. He doubled down on this fake heart attack. Well, of course, he was busted. The court found out, checked up on him, realized, no, it's not this attorney there. It's some old lady. But nonetheless, it turns out this was not this attorney's first time pulling the Fred Sanford. This was his second time pulling it and his third ethical violation. So the deal I'm going to offer you is a 1-year suspension. Would you take a 1-year suspension for pulling the Fred Sanford? We'll give you some chance, time to deliberate that, to think about it. You know, your life is on the run. You got 1 year. You can get your life in order. Hey, you can go to get your heart taken care of. That's always going to be a plus and a benefit. Here's the reality. A lawyer, obviously under Rule 3.3, cannot lie to the court. You cannot make a false statement of law or fact to a tribunal. You cannot fail to correct a false statement of material fact previously made with the tribunal. And of course, under Rule 8.4, you also cannot engage in dishonest conduct. So yeah, pulling the Fred Sanford is a 3.3 violation. That lacks candor with the tribunal. But here's the other thing about this. I've in teaching this class across the United States, I review all those different ethical violations, and a common theme that we see is that sometimes courts will be mercy. A court will extend a little bit of grace the first time around. If you plead mea culpa, you cooperate in the process, the court might extend you grace. But man, you better be a quick learner, because if you come back to the court and you haven't learned your lesson, yeah, you're trying their patience. And this was the third time. And so unlike my Kansas City Royals pitchers who have no idea what this concept is all about, California follows the 3 strikes rule and you are out, and he was disbarred for pulling the Fred Sanford to get out of court. So yes, that is the 3 strikes rule and you are out. A very common rule that most jurisdictions follow. You better be a quick learner and do not come back to the disciplinary panel again and again, because their patience, it will run out at a certain point in time. So, all right, there's a lot of takeaways from this this story here. One takeaway might be, have you heard of the flu, right? If you're going to fake an ailment, why are you going to fake something so easily disproven? But nonetheless, I one time had the flu, and it was I had court that day, and I didn't know. Are you allowed to get out of court when you are throwing up? I did not know if you could do that. And so I just brought my trash basket with me. I was up there giving argument to the court with a trash basket in hand. The court never knew I was sick, but nonetheless, apparently I have heard from other attorneys that that is a viable reason to get out of court if you have the flu. All right, moving on here now to our next deal or no deal. Oh, well, firstly, we got this. Again, I want to throw these ideas by you of when it might be time to get a new lawyer. And so related to this story is, if a lawyer has ever told a court, you know, Your Honor, I have to tell you the truth on this one, well, it might be time to get a new lawyer. Yeah, you got to be honest with the court at all times. So there you go. All right, moving on here. Our next deal or no deal, and this is in Ray Klein. So here's what happened in this case. This actually involves a judge, and he was kind of, I guess, abused his duties, his position there as a judge, and so a settlement came up to this court over a class action case. It was a class action situation, and a settlement was proposed where the plaintiff's attorney would get $125,000, but the class members would only get a $10 gift card. Now, right there, that is one of the problems with class action settlements. You know, it seems like the violator of the law, the company, gets a benefit because they get free advertising, because that $10 gift card can only be redeemed at that store by purchasing future merchandise, and so it seems to be a profit, free advertisements and coupons for that the company. So that's what the offer, the settlement that went before the judge. Well, the judge did not like this settlement offer, and so he basically thought his hands were tied, but thought he had a little bit of wiggle room here to effectuate his dissatisfaction with this settlement. And so the court approved the $10 gift card, but then ordered that the attorney's fees of $125,000 be paid also in $10 gift cards. Yes, he ordered that the attorneys receive 12,500 gift cards that he could put toward the purchase of any merchandise he liked. Now, here's the other kicker on this one. this was a women's fashion store. And so, yes, the he had to spend 12,500 gift cards at a women's fashion store, and this was a guy. So, yeah, does seem to be a little bit of an odd kind of order from the court. The judge then took this order and sent it to the press so that they would report on it. And so the court obviously was trying to make a statement of some sort. So the deal that I'm going to offer you is, how about this one? Banned from ever being put on my Christmas present list. Okay, that one might be more for me. I don't want to receive those gift cards, but nonetheless, the actual outcome of the situation was public censure, and he was banned from hearing any future cases. Now, I think that's a really severe kind of punishment for this judge. He was already retired, so he didn't care and didn't offer up that big of a defense. But nonetheless, in the decision censuring this judge, the court said that his conduct displayed bias and something called embroilment. I have no idea how opinion represents embroilment, but that's what this order said, and it reflected a failure to be patient, dignified, and courteous to those appearing before him, and so he was publicly censured and banned from hearing all future cases. All right, well, it kind of leads me to my next. It might be time to get a new lawyer quip. If your lawyer has a tip jar on the receptionist's desk, well, it might be time to get a new lawyer. This is especially true if there are no green bills in there and it's just coins. Then your lawyer, it really is time to get a new lawyer. All right, moving on here next. This one, In Re Honorable John Murphy. I guess I've been teaching this class now for 4 years. In my 4 years, this is probably my favorite case, my favorite clip to play in classes. I've been playing for 4 years. I still find it hilarious 4 years later. Now, if you're a thinking person, you realize what I just said. There's some good news and bad news. The good news is, yeah, this promises to be a really entertaining, informative, and educational clip. The bad news is this class is going to go downhill from here. This is the pinnacle of the class, and there might be some truth to that. I am not sure. But nonetheless, this is a judge in Melbourne, Florida, which is right off the East Coast there in Florida. I used to live in Orlando. I still have a Florida bar card, but nonetheless, Melbourne is just a little bit away from that. It's on the East Coast, a great place to go surfing. And so John Murphy was holding court there one day, and the public defender was there, and the judge wanted the public defender to waive the defendant's right to a speedy trial. Now, that's not an unusual request from a judge, but this public defender did not want to waive the right to a speedy trial, and boy, did that tick the judge off. And this is how the judge responded.
Dear Mr. Runkles.
Yes, sir.
Chief charges assault and resisting. Do you have the public defender? Public defender, what do you want to do?
But they thought.
They have.
I'm not waiting.
All right. What do you want to do?
What do you want to do? I'm not waiting. You want to set up a trial? Set up a trial.
All right.
If you want to set for docket sounding, set for docket sounding. I'm not waiting in any case. This is an emergency.
If I had a rock, I would throw it at you right now. Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, you know what? I'm the public defender. I have a right to be here, and I have a right to stand and represent
sit down. If you want to fight, let's go out back, and I'll just
let's go around.
Yeah, that's what he did. The judge asked him, hey, you want to go back and fight? And so they went back and fought, and the judge said, you want to F with me? Well, do you? And the judge is pummeling this attorney in the back hallway. Oh my goodness, there's so many different takeaways on this story. Why don't we start here? The first takeaway is under Rule 3.3, we owe a duty of candor towards the tribunal. All right, we get that. You got to be honest. But I am wondering, is there an outer limit to that duty of honesty? I don't think the duty of honesty quite extends to this reach, where when the question is asked, do you want to fight? Your answer has to be, well, hell yeah, I've been waiting for this moment all my life, Judge. Thank you for asking. Let's go at it. Watch how fast it takes this attorney to contemplate the question.
If you want to fight, let's go out back and I'll just
Let's go to the house.
If you want to fight, let's go out back and I'll just
Let's go to the house.
All right, he doesn't even think about it for a minute. It's like, boom, yeah, let's go, Judge. I do want to fight. Thanks for asking. Yeah, there is no pause. There's no contemplation. There's no waffling around in his mind, you know, the pros and the cons. Like, yeah, hell yeah, I want to go fight. So they go in the back hallway. So let me just tell you here, right, that was not a very wise or prudent acceptance decision on his part, because the judge, when he was arguing before the Florida Supreme Court to save his job, this is what he argued. The judge said, Your Honor, you got to understand, I've gone through a rough time in my life. It was a difficult time. See, I suffer from PTSD, that's post-traumatic stress disorder, from my days in the military. Yeah, let me just pause here. Did you catch what I just said? Days in the military. That was not a very wise acceptance of a fisticuffs engagement. If you ever accepted a fisticuffs engagement when you were in grade school, one of the things you thought about as you were mulling that over is, what are the qualifications of this other person? If it is the schoolyard bully, you're probably not going to be so, readily acceptance of that offer. Here, the judge, I kid you not, had been in special ops. He had special ops training. That was not a good call by this attorney to accept that fight. So he got us clean clocked, and yes, that was pretty much foreseeable. If that had been me, I would have said, you know what, Judge? I'm thinking let's submit this one on the briefs. Yep, this is a good one to submit on the briefs. Why don't we just do this one via the written word and not meeting in the back hallway? But nonetheless, that's what he did. And so let me give you the offer for the judge. Now, I get a lot in my live class, a lot of attorneys will say, well, what about the attorney? He's the one that accepted that fist fight in the back hallway. He's the one that, shouldn't he be held responsible in some way? Well, probably not. I mean, he has not been disciplined. He did quit his job. He moved out of the county because what happened was the judge came back into the courtroom to a standing ovation. The crowd gave him applause. They loved what the judge did. Either that or they were scared for their lives. I don't know. Either way, they gave the judge a standing ovation. And I gave this class in Orlando, Florida, and one of the attorneys there knew all the players here. He regularly appeared in his court there in Melbourne, Florida. He said, Joel, you got to understand, yeah, this guy had it coming. I mean, he was a Class A jerk in court. He was always getting under people's skin, and so that's why they were always excited. But nonetheless, no violations, no disciplinary proceedings against the attorney. It's just the judge that we are focusing on. Is that unprofessional conduct? And so he did argue this is a tough time in his life. But nonetheless, the Florida Supreme Court said this. And I'm just reading, I'm summarizing the order in which the opinion came out because it kind of shocked me when I read it. But the Florida Supreme Court said, Judge, we understand you're going through a rough time in your life. We get that from your PTSD, from your days in the military. Thank you for your service, by the way. But you got to come to grips with the severity of the situation. You got to understand the gravity of the matter. See, Judge, you swore in court. And I'm thinking, really? Is that really what you had a problem with? His potty mouth in court? How about the fact that he also invited this guy in the back hallway for a fist fight, cleaned his clock, and then came back into court and continued to accept waivers from clients who had no attorney? He was moaning and groaning in the back hallway. So apparently when that judge said, just sit down, I don't need your help, he wasn't kidding. He does not need the help of attorneys to do his job. Yep, just lock him away. I'll take care of it all by myself. Well, again, the deal I'm going to give you is a 1-year suspension for this judge. Would you take that? Might be a good opportunity to get some anger management counseling, gets the PTSD dealt with, but nonetheless, the actual outcome was permanent removal from the bench. And so, yes, if he wants his job back, well, he's in Florida, he's going to have to run for re-election. So that is unprofessional conduct from a person sitting on the bench. All right, kind of brings up to our next. It might be a time to get a new lawyer if. And so here you go. If your lawyer's secretary wears a shirt at work that says, "I'm with stupid," well, it might be time to get a new lawyer. All right, moving on here to the next one. Hope these are giving you guys some ideas as to examples of when it might be a good time to get a new lawyer, because if you're watching the news at all of late, I am also thinking when your client, when your attorney, implicates you in a felony crime as a co-conspirator, that also might be a time to get a new lawyer, but I am just digressing. All right, moving on here to this next deal or no deal. This one really hits home with me because I've been there before. I used to work for a lawyer in a law firm where, if you're filing an appeals brief with an appeals court and in federal court, you get 14,000 words. And if I submitted my brief to my supervising attorney and it had 13,999 words, he would send it back and says, Joel, you missed a word. Go find a place to add in one more word. He wanted to use up every last word in the briefing allotment. So this is what happened here in the PyNet case. These attorneys were writing a brief, and they filed this appeals brief that had it complied with the rule. It was under the 14,000 limit, but how they got there was by taking spaces out of their sentences. Yes, they would write sentences without spaces, so that when it showed up on the computer's count, it would just be one word. This is actual something that was put in the brief. It was Thorner v. Sony Computer Entertainment Amp. You see the citation there all the way through with no spaces. So as that is read by your word counting software, that's just one word. Well, the court had none of it and told them, look, guys, you got to fix this. That's dishonest. That is not one word. That's multiple words. So fix your brief. They didn't get the message. They filed a second brief also with the same kind of shenanigans, and the court had enough. And so the deal I'm going to offer you is, well, actually, no, I'm not going to offer you a deal. I'm just going to tell you the outcome of that case. The court struck the brief. And so, yes, they filed an appeal, filed a brief with it, and their brief was stricken. So you know what this means, don't you? Next year, we're going to be talking about their ethics charge of a Rule 1.1, a violation of competency. I am thinking of filing an appeal, then having your brief be stricken because you don't know how to put a space between your words. It's not going to bode well for your future. So we'll have to stay tuned for next year to see how that comes out. But again, that is a violation of the attorney's duties. It is dishonest with the court, and they were disciplined for it, at least to the sense of their brief was stricken at this point. All right, let's move on here to our next case. In Ray Sutton. And I hope you've never been in trouble with a disciplinary panel, but if you had, you know this to be true. And if you go through these cases, you also, it's been very clear and obvious that if they're going to come after you, they're going to come after you with everything they've got, plus the kitchen sink. And so we have 4 claims were brought against Mr. Sutton. Our claim number 1, he is in court, and he leans over to his witnesses on the witness stand, and he tells the witness under his breath, the judge is a cockroach. All right, now here's a tip for you non-litigators on this webinar today, all right? There are microphones on witness stands. Yes, I know you might not regularly go into the courtroom. That might not be readily apparent to you. I'm sure all you litigators immediately picked up on that. But yeah, there are microphones on witness stands, and the judges are connected to that microphone. They don't like to be called cockroaches or any form of that word for the matter. If that's how you feel, just excuse yourself, go use the restroom, check out the stall next to you to make sure no one is there, and then just share whatever's on your heart. But for crying out loud, don't call the judge a cockroach from the witness stand. Yeah, it's not going to end well for you. All right, count number 2. He goes into a bar, and he gets into a bar fight. Apparently, members from Hell's Angels also don't like to be called cockroaches or any form of that word for the matter, and so he gets into a bar fight. He gets arrested for disorderly conduct. You can just imagine your lawyer there in a bar fight getting his clock cleaned. Yeah, that reminds me of another situation when it might be time to get a new lawyer. I'll have to work on that one after this class, but nonetheless, gets into a bar fight, gets arrested for disorderly conduct, and that becomes count number 2. All right, count number 3. Now, have you ever heard a story? Some speakers was talking about a story. He said, man, But by the grace of God go I. I mean, that could easily be me in that story. Well, I see a lot of myself in this next count. I see a lot of myself in count number 3, because he was in road construction. And I gotta tell you, I absolutely hate road construction. I loathe it. There is not even a word in the English dictionary that accurately describes my utter hatred towards a road construction. One of the reasons is because my car's AC doesn't work too well, and so whenever you are not moving, your AC is not working as well, and so you're in the afternoon sun, the sun is beating down on you, you're sweating bullets. It's maddening. All of a sudden, Mr. Sutton had this great, brilliant idea, light bulb moment, if you will. He goes, wait a second. I drive an SUV. They build them all the time. They advertise it as being off-the-road vehicles. And so I'm no longer restrained by the actual boundaries of the road, right? I'm free. And so he took his car, his SUV, he drove it off the road and through the road construction. I got to be honest, this guy, he's my hero. I mean, this is great. I am eating this stuff up. We have been limited in our entire lives by things we cannot drive through road construction. But no, we drive these Jeep Cherokees, these SUVs. They run advertisements of them in the mountains. Surely they can handle a little bit of road construction, right? Well, apparently this cop was not too impressed. And this cop puts their stop sign right in front of Mr. Sutton. So what does he do? Well, Mr. Impatient turns into Mr. Road Rage, and he hits the cop and he hits the stop sign. Yeah, by the way, this is where I stopped to identify with him in the story. Yeah, I don't see myself ever doing that, thank goodness, but he hits the cop, he hits the stop sign, he then reaches in his car and grabs a bottle. Luckily, it was a Pepsi bottle. He would have been in even worse trouble, but he grabs the bottle, he chucks it at the cop, and then he drives away. So, Mr. Road Rage, that becomes count number 3. All right, count number 4. He goes to a legal seminar. Now, it wasn't mine, or he would have known better, especially after hearing the story about himself. But nonetheless, he goes to a legal seminar, and afterwards, he submitted his expenses to his employer for reimbursement. All right, there's nothing out of the ordinary there, right? That's standard business protocol. You go to an all-day business event. You have a nice lunch. Why? It's on the firm. It's all expensible. There's nothing wrong with that. And then on the way home, yeah, as long as it's not too much of a detour, not too much off of your way home, you stop off, you have a nice dinner. It's all expensible. It's all good. That's called the boondoggle. Totally allowed under the rules. Everyone knows about the boondoggle. I'm a very proficient boondoggler. But what he then did is he took those same receipts that he sent to his employer for reimbursement, copied them, and sent them to a nonprofit organization for reimbursement as well. Nobody, you cannot double dip, and you cannot double expense. It is unethical, not to mention a little gross, but nonetheless, that is what he did. So all 4 claims go before the disciplinary panel. All right, as to count 1, calling the judge a cockroach, and count number 2, the bar fight, do you know how the panel ruled? No violation of the rules. So I want to be very clear here. If the only thing you get from today's seminar is, hey, I'm looking at my notes right here. It says, it's okay to call a judge a cockroach. Well, then remember, my name is Joel Osteen. I don't want any credit for that kind of thinking. But as it counts 3 and 4, he was disciplined for that. And so the deal I'm going to give you is a 1-year suspension. Would you take a 1-year suspension for throwing something at the cop, hitting the cop with your car, double expensing? Yeah, it is dishonest. It is a violation of Rule 8.4. Sure doesn't seem to be professional conduct. I don't want my lawyer losing his cool like that. But it is driving, but still, even though it's not related to his legal practice, it is dishonest. It does cast doubt to his fitness to be a lawyer. If he loses his cool there, is he going to lose his cool in court as well? Well, nonetheless, the actual outcome was public censure. Now you might be thinking, well, wait a second, that seems rather light. Well, here's another common theme that you do see in these rules. And again, this is not a guarantee. I'm just telling you this is a common theme that I see. And that is this: if you cooperate, and which, by the way, you are obligated to do under the rules, but nonetheless, if you cooperate, you plead mea culpa, you take ownership, you say, this is my bad, this is on me, I do see how I did this and it was wrong, and I put steps in to make sure I don't do this in the future. Yeah, that's what they want to see, and if that's what you do, they might cut you some slack the first time. Again, I do want to be careful here. I'm not saying go ahead and act crazy and then you'll get your one free pass. I'm saying if you have acted crazy, it's going to bode better for you to cooperate in the process. And by the way, you're obligated to do that anyways under the model rules. All right, and this next case, motion to bifurcate, or is it a motion to obfuscate? Now, in this, but why is it that we as attorneys have to take continuing ed classes every single year? Have you thought about that? Why do we got to take continuing ed classes in some states up to 3 hours every year, right? Well, here's why they you have to take ethics classes every year. It's because the bar associations want to scare you straight, right? They want you leaving a CLE class saying, wow, thank God I am still an attorney. If they only knew what I have done, there is no way they'll let me continue to practice law, and so I better keep my nose clean from here on out, or else I might be finding a new line of work, right? It's to scare us straight, and that's why in that light, that's why I have this next case. This happened to a friend of mine in El Paso, Texas, and so he was in court one day and arguing a motion to bifurcate, and the judge asked him, did you file a motion to bifurcate these claims? And my friend told the court, yes, I had filed that motion. All right. My friend then goes back to his office, digging through his files, and realizes, oh crap, he had never filed that motion to bifurcate the claims, and he had told the court that he had filed that motion. So he goes back to the court and says, Your Honor, you asked me if I had filed a motion to bifurcate those claims. I told you I had. Turns out I had not. I just want to make sure you know about that before you rule on this matter. I want to set the record straight. And so that's what happened. Now you got to understand, there was no strategic advantage for my friend to lie to the court. He honestly believed he had filed that motion. See, I too had appeared in that very court, that I was arguing a motion that had not been filed. And so the judge asked me the same question. So what we did was we took out a piece of paper, because the judge, by the way, told me to do this, and write down, I hereby move for blah, 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 and hand that written piece of paper to the court. That's how he fixed it right there in open court. And so it wasn't a big deal. There was no strategic advantage to lie to the court. All right, so that being said, here's a deal I'm going to offer you. Public admonishment. Would you take a public admonishment for doing that in court? Now, I don't see you guys, but I know what's going through your mind, at least most of you, because I hear it in my live class. And that is this: you're thinking, no, I'm not going to agree to a public admonishment because he did nothing wrong. This wasn't dishonest. There was no lack of candor. This wasn't even a lie. Well, just hold your horses just a bit. You see, you are required to know the pleading history of matters you are arguing in court. Here, this attorney was arguing this bifurcation motion. He had a duty to know the answer to that question. So when he told the court affirmatively he had filed it, well, it lacked candor with the tribunal. All right, so you get that out of the way. It still seems a rather small, minor transgression. So you don't want on your record a public admonishment for this, right? Well, I see where you're coming from. I get that. Let me go ahead and tell you the actual outcome of the case. 90-day suspension from the practice of law. Yes, I'll give you time to get back out of your chairs. Yes, this guy was suspended 90 days for that very statement. He had to send letters out to his clients saying, I'm no longer your attorney. I've been suspended because I lied to the court. He had to return retainer agreements, find a new counsel for his clients. I gotta tell you, he was nearing retirement anyways. He never recovered from this ordeal. He took this as an opportunity to go into early retirement. And so this is a violation of Rule 3.3 does lack candor with the tribunal, and so it is a violation of the rules. Now, you might be thinking, because I know what's going on in your mind, you might be thinking, Joel, I think you're holding something back on us. I think there's more to this story. Well, let me be the first to tell you, that is what you are thinking. You are right. Yes, there is more to this story. I am holding back on you. My friend is also what's called a Class A jerk. I am sure you know exactly the kind of guy I am talking about. You run up against them in court every day, and it makes you regret getting out of the MCAT line into the LSAT line. Why didn't you listen to your mother and go to the medical school and you picked law, right? It makes you rethink all of your life's choices. They make the practice of law miserable. They make mountains out of molehills. They blow everything out of proportion. To give you an example of what I'm talking about, my friend one day was in a trial in court, and there's a visiting judge, and the judge was coming from East Texas to West Texas to preside over one of his cases, and the judge sent an email out to all clients, all parties, saying, hey, trial's going to start Monday at 9 o'clock, be on time. So how did my friend respond to that email? Get this. He sent an email out, or he filed a motion to recuse the judge, and then alerted the media, issued a press release to the media calling the judge a racist. Yes, you heard me, a racist. Well, wait a second, how is that a racist? What's racist about that? Well, you see, a statement from someone from East Texas to someone who lives in West Texas, that is a border city, telling them they have to be on time, is akin to saying you are Hispanic and therefore lazy. You have to be reminded what time court starts. No, that's not a racist email. That's just simply saying be on time. We're going to start at 9 o'clock on Monday. But that's how my friend approached litigation. He made mountains out of molehills. So the moral of this story is, if there ever is a time in your practice when you need the court's grace or mercy, well, don't be surprised if you are a Class A jerk in the courtroom if you do not get the court's mercy. The court might not be feeling so inclined to extend mercy to you if that is how you practice the law. That is what happened to my friend there, and he, again, was suspended 90 days. So the other takeaway from the story you're probably thinking is, Joel has got to get better friends. Well, that may be true as well, but nonetheless, let's move on here to our next deal or no deal. All right, this here is a tale of a lawyer and his 3 clients. Now, I should apologize to those of you up front for the subject matter of this story. But upon further reflection, I realized I can't apologize. This is a story that needs to be told. I have met with many ethics compliance officers in various states, and they all tell me the same story, that well over 50%, one state even told me over 60% of their ongoing cases violations involve this very issue. So what the story I'm about to tell you involves a subject matter that attorneys sorely need to hear about. All right, here it is. The story of a lawyer and his 3 clients. You got client A, client B, and client C. All right, with client A, he was a divorce attorney representing this lady in a divorce. And so she sent him a text message of her, let's see here, how can I put this, sans clothing. How about in her birthday attire? I think they're called sext messages nowadays, and so that's what she did. She sent him a picture of him without her clothes on. All right, so he had a choice right? He had some options in how he responded to receiving this text message. He could have said, all right, thank you very much for this document. In fact, I am doing document disclosures right now to your soon-to-be ex-husband. I will make sure they get this document post-haste. Thank you for your prompt response in this matter. All right, he could have done that. He could have said, you know what, that's not really an appropriate way to talk to your attorney. Maybe I led you astray here, misled you in some way. But no, that's not really appropriate. Let's just keep it clean and keep it professional from here on out. But because this is a story I am telling you, you know he did not choose that option as well. Instead, he decided to respond in kind and sent her a text message of his junior partner. That's what he did. He engaged in inappropriate communications with his client. All right, client B there. You He's feeling somewhat emboldened with how things went with client A, and so he engaged in inappropriate communications with client B, but then added to that a text message that said, "Hey, I just came from snip and clip and had a vasectomy. Why don't you come over to my office and we'll engage in some carnal relations without a saddle?" Yes, those aren't my words. Those are the court's words, quoting him. That's what he said. Apparently, that's a come on in today's day and age. I had no idea, but that's what he said. And so that's what she did. He added to inappropriate communications, inappropriate relations. Wow, Joel, there's a third client down there. How could this get any worse? Well, it did get worse according to North Carolina Supreme Court, but I'm going to let this next video tell how it got worse.
So I was standing right over there, and these cops come over and they tell me to get in. And I said, huh? And they're all like, "You're under arrest." So I go down to the place, and I didn't call Saul or nothing. But he comes in, and he got me out. And now I don't have to go to jail. I think I might owe him some money, but he said we'd work it out.
There you go. Saul Goodman. Better call Saul. By the way, does anyone know how Saul Goodman got his name? Yeah, he wanted to change his name to make it more marketable, so he changed it to Saul Goodman. Because if you say it slowly, well, if you hire him as your attorney, it's all going to be good, man. It's all going to be good, man. And so, yeah, he changed his name to Saul Goodman. By the way, there actually is a real case of an attorney changing his name for marketing purposes, but that will be in future classes. Just discovered that the other day. All right, well, nonetheless, yes, that is what Attorney Smiles did. He engaged in inappropriate communications, added to the inappropriate relations, and then thought, you know what? I think I've been fully compensated for my legal services. There's no need to pay me anymore. So he reduced his bill $4,300. Now, I got to tell you, when I read this, a decision from the North Carolina Supreme Court, I am thinking to myself, is this really on the same par as the other two violations? Really cutting your bill? Is that on the same par? I mean, yes, I can kind of see inappropriate communications. I understand inappropriate relations, but cutting your bill? That just didn't seem to ring as big of a violation, but here's how the logic went. I said, you work for a law firm, and so you're under contract, you have an obligation, a duty, if you will, to share your compensation that you receive on a case with your fellow partners. And this would not be something you could readily share with your fellow partners. And so he was busted. They said, yeah, these fees belong to the law firm and not to you. And so when you slashed your bill $4,300, under the three, you've already been fully compensated. This is going to be a problem under the model rules. And so he was written up for all three violations. By the way, sometimes it's kind of fun and interesting, isn't it, to hear the rest of the story? I mean, how did a guy get busted? How did he get found out? Well, here's how he got found out. Another person went to another law firm in town seeking some legal help, and that lawyer said, you know what? I'm not really the guy for you, but you know who can help you out? Attorney Smiles is the guy. He can help you out. And that person said, you know what? No, I would rather not go to Attorney Smiles. You see, he has a rather sordid, interesting reputation. And that lawyer said, really? Do tell. I have no idea what you're talking about. And so that person then told them about Attorney Smiles' reputation, what he's been doing. And so that lawyer immediately went to Attorney Smiles' bosses and said, you better check out your guy there. He's doing some funny business there. So they called an immediate hearing with Attorney Smiles. I think that meeting went something like this.
I'm going to get right to the point. It's come to my attention that you and the cleaning woman have engaged in sexual intercourse on the desk in your office. Is that correct? Who said that? She did. experience on this thing, because if anyone had said anything to me at all when I first started here that sort of thing was frowned upon, you know, because I've worked in a lot of offices, and I tell you, people do that all the time. You're fired. Well, you didn't have to say it like that. I want you out of here by the end of the day.
Yeah, I'm pretty sure that's exactly how that conversation went. Dude, you are fired. And so that's what happened. Now, what should be his punishment for engaging in inappropriate communications, inappropriate relations, and then cutting his bill $4,300? Well, the deal I'm going to offer you is disbarment. Would you take disbarment for doing that kind of thing? You might be thinking, well, how can it get any worse than disbarment? Why would I accept that deal? Well, it is pretty serious stuff. This is going to be a violation of the rules, clearly. You cannot engage in that kind of communication with your client. You cannot engage in the kind of relationships with your client. And so it's going to be a problem for you. But maybe if you, agree to a deal, you just kind of quietly go away. Yeah, future CLE talkers would not be talking about your case in future classes. There's always that. But nonetheless, it is kind of the worst of the worst. The actual outcome was, drum roll please, 5-year suspension. So very similar to a disbarment, but here he is going to get a chance to practice law again at the end of 5 years. And so that is going to be, again, this is obviously a violation of the rules. And he had to pay a high, stiff price for doing it. All right, next case here. The next deal or no deal is the bar complaint done Jerry Springer style. Now, I am assuming there are not too many Jerry Springer fans on this webinar because, well, you got to work during the day. We don't have time to watch Jerry Springer. I have no idea if he's even still on the TV, but again, we know what I'm talking about when I say Jerry Springer style. It's a crazy, sensational fact pattern. And yes, that's the fact pattern that exists here. It's crazy, it's sensational, and so try to bear with me as I describe it. All right, you got an attorney who's representing a guy who's divorcing his wife. All right, so you got an attorney representing this guy who's divorcing his wife. Meanwhile, the attorney then has an affair with the guy's girlfriend. Now you know why he's getting divorced from his wife. He has a girlfriend on the side. All right. And so while this is going on, the soon-to-be ex-wife files a stalking charge against the girlfriend. And so there's a cross litigation going on here of stalking charge. And so the attorney that represents this girlfriend that he is sleeping with now in these stalking charges. All right, well, meanwhile, this attorney's office manager starts to get suspicious about what her boss is doing. He's like, I think he's having an affair with the client's girlfriend, now current client. So she goes digging through his emails and whatnot and confirms, yeah, he's having an affair with the client's girlfriend, now current client. And this really ticked her off. You see, one of the things I forgot to mention is this office manager is also his wife. And so she was very livid. And so she took all these emails and these text messages and she sent them to the attorney on the stalking charge and the divorce case, sent them to the other side. So that's the crazy fact pattern. So what should be the punishment here? Well, the deal I'm going to offer you is a 90-day suspension, but we got to analyze what is it that he did wrong, because it might not be so apparent at first glance. The first thing I thought about was, well, clearly he's having an affair. You can't sleep with the client's girlfriend, now current client. That's just wrong. You can't do that. Well, according to the disciplinary panel, he got that one in the right order. Apparently, this was not a conflict with his existing client. Their interests were aligned on this matter. I have no idea how that's the case. Maybe there was a signed waiver of conflicts on that, but nonetheless, they said he got that in the right order because it has to be romance exists first, and second, legal representation. And here, he did it in the right order. He did not flip it. The romance happened before he represented the person, and so that made that deal okay. Again, I'm not saying that's okay according to our maker, no. But according to the disciplinary authority, they said he got that one in the right order. All right, but what about the documents that were sent over to the other side? What did the attorney do that was wrong? I mean, was it negligent for him to give the office manager his passwords? Well, no, it happens at all these law firms. You work, your secretary, your office manager will have access to your passwords. They'll keep them and store them. That's a common practice, so that's not negligent per se. But here's the deal. I think the court is just simply saying, look, under Rule 5.1, you are responsible. You're the supervisor of your office. If you're the one that's going to be too stupid to have an affair when your office manager is your wife, dude, this one's on you. And so now the deal is going to be 90-day suspension. Would you accept that? Well, actually, the case is still pending. Let's come back next year and find out the actual outcome of this case. All right, moving on here to our next. It might be time to get a new lawyer. How about this one? If your divorce lawyer asks for your soon-to-be ex's number, well, it might be time to get a new lawyer. You actually got that from another lawyer that happened, so there you go. All right, let's go to our next deal or no deal. How are we doing on time here? Oh, we're doing fine here. Let's go. Actually, no, let me skip it through some of these cases here to get to a couple. Interest of time here. We're going to jump here to this one is In Ray is the California attorney, and she, like many attorneys, wanted to get a leg up with her marketing approach. She wanted people to kind of remember her, so she kind of thought outside the box, and this is what she came up with.
California lawyer under fire this morning for pictures she posted on her website showing her with A-list celebrities. Turns out those photos were fakes, and ABC's Paula Ferris explains why this is a problem. George Clooney, Leonardo DiCaprio, Jennifer Garner, even President Obama, all pictured with the same woman, Los Angeles attorney Svetlana Sangari, who posted the star-studded snapshots to her business website. The problem? These photos are creating the wrong kind of exposure. That's because the California State Bar says the photos are phonies, described in court documents as false and deceptive advertising intended to confuse, deceive, and mislead the public.
The State Bar deems that your website is a solicitation for an advertising for services, and it has to be truthful.
The California Bar now requesting Sangari be suspended for 6 months. They say she was asked to remove the false photos months ago, but didn't. A State Bar court judge also writing in his decision that while Sangari did eventually respond to the court's disciplinary hearing, her response had little or no rational connection to the charges at hand, including a tangent about the movie Black Swan. The decision also notes that Sangari refused to testify on her own behalf until forced to.
Failed to cooperate with the State Bar, and in fact didn't even show up portions of her trial.
This morning, no word from Sangari about just why she did this. ABC News reached out to her overnight, did not hear back, so it's now up to the California Supreme Court to decide on that 6-month suspension. Very real consequences for those fake photos, which I have to admit looked a tad authentic.
All right, so she wanted to get a leg up on her competition, and so she wanted to appear like she was, hey, I'm connected with the Hollywood A-list celebrity crowd. I'm really cool. I hang with the cool guys. And so on her Facebook, on her website, were all these pictures of her butting up, hanging all over, hugging, you know, all of these A-list Hollywood A-list celebrities. And so you know, the idea there is that these were Photoshop pictures. These weren't real pictures. They were obviously Photoshopped. And you can always tell a bad Photoshopping job, right? It looks kind of weird. Well, this deals with Rule 7.1, attorney advertising. So let's unpack Rule 7.1 in just a bit. In 7.1, it applies to any and every mode that you use to advertise your legal services. And so it runs the whole gamut. I mean, it applies to yellow page, attorney ads. Now, wait a second, maybe I should just pause here. Do you know what I'm referring to when I use that term yellow pages? To kind of jog your memory, maybe your childhood days. I remember when they talked about the yellow pages of old. Yeah, well, the yellow pages are the big old fat yellow book that gets thrown in your driveway once a year that you immediately pick up, walk over to the garage, and drop it off in the recycling bin. Yeah, the yellow pages don't even enter the house anymore. We had one delivered to our house this last year, and I was just curious. I picked it up. Sure enough, an attorney is still advertising in the yellow pages. Now, come on. Would you really want a client who had not heard of Google? No, I don't care what the billable hour is. it's not going to be worth that kind of a headache. They don't even know what Google is. That's not going to be a very easy ride. Well, nonetheless, if that's you, if you advertise in Yellow Pages, Rule 7.1 is going to apply to those ads. But in addition, this same rule applies to your social media posts, your Facebook post. And yes, that should scare a lot of you, because there is a lot of lying going on Facebook, right? I mean, you read about these your neighbors down the street, oh, let's call them the Joneses, and they took this perfect vacation to the French Riviera, and they post these pictures of their kids. Oh, they're so perfectly dressed. Look, they're so well behaved and mannered. Look, they're smiling. And then you are bummed about your life because you don't have a perfect life like the Joneses. No, they are lying. Those aren't even their real kids. They had to pay those kids to come in and stand in for that picture because people lie on Facebook all the time. That's why it's called a fake book. We all get that. But when it comes to your legal services, no, not even having the guise of Facebook allows you to distort the truth. You must tell the truth when it comes to your legal services. All right, so that being said, it's how the rule works. Well, that's what the rule applies to. How it works is it prohibits misleading advertisements. And yes, it is that simple. You can look at the entire rules. It covers several rules and comments and things like that, and opinions. But here's the bottom line. Don't mislead. As long as you are not misleading, you're going to be fine. But here's the problem. Your mother was right. Half-truths are also half-lies. If you have teenage boys, you know that to be very true, right? I have a teenage son, and it's almost comical how he will dance around telling you a story, selectively telling you facts, trying to lead you down the primrose so that you can come to a conclusion. Yeah, he's being truthful and deceptive at the same time. Well, the state bars know that, and you can't do that in your attorney advertisements. And so that being said, let's hear her defense before we decide what her punishment should be.
Attorney accused of photoshopping speaks out in exclusive interview. A California attorney who made headlines after being accused of photoshopping herself into dozens of photos with celebrities is now sharing her side of the story in a one-on-one interview with Tomo News. Last month, the California State Bar Court recommended that Svetlana Sangre be suspended from practicing law for 6 months. After an investigation showed her website featured fake publicity photos of her next to big-name celebrities, like George Clooney and Ellen DeGeneres.
But pictures always speak louder than words, and pictures are worth 1,000 words.
But are the pictures real or fake? Sangre, an LA-based attorney, presented us with a stack of documents showing that over the years, she donated tens of thousands of dollars to political campaigns.
I became a major donor, and that's how I got invited to all these events where I had an opportunity to socialize, briefly speak, shake hands, and be photographed with these prominent, talented, and successful people.
In our interview, Sangre also presented us with a CD that included dozens of photos. She even brought along a Photoshop expert who analyzed the photos. In a written report, he found the photos were authentic. The Tomo News staff took a look at the photos as well and didn't see any real signs of manipulation. But we did notice that some of the photos on her website were nowhere to be found on the CD, including this photo with George Clooney that bears a striking resemblance to a photo he took with his then girlfriend. Also, this picture of Sangre with President Obama from the CD is a far cry from this one from her website. Are these the photos that are on your website?
I didn't design my website, so I don't know which photos are on my website.
Well, now, you can be the judge. We posted all of the photos that Sangre gave us on Dropbox, and you can find a link in the description below. Check them out and tell us what you think in the comment section. For Tomo News in Los Angeles, I'm Sasha Horn.
All right, so the deal I'm going to give you for these fake Photoshop pictures, is a public reprimand. And so let's unpack here what she said in her defense. She said that she did pay the big bucks to attend these high-priced events. So she was in the same room with these A-list celebrities. Apparently she had the documentation to prove it. But did you see that one picture that she took whereas her, Obama was clear in the back corner, and so she took a selfie, but her face is up front. He's in the back corner. Somehow, when that picture ended up on her website, they're kissing cousins. They're hanging all over each other. They're their best buds. And so obviously something was going on there. Some little photoshopping shenanigans were going on. But she said, you know what? I'm the wrong person to talk to about that. I see someone else runs my website. No, you are the attorney. You are the right person. You cannot share the blame like that or pass the buck along. So the deal I'm going to offer you is a public reprimand. Would you take that for Photoshop pictures? And again, if you think this through, the answer is obvious. Yes, you should take it. In retrospect, this is not a big deal at all. Yes, this is misleading. Take the pictures down and move on with your life. But she did not like that option. She did not take that deal. And instead, she decided to, well, I don't know what she decided to do, but she refused to attend her own hearings. Not a good thing. The bars like for you to cooperate, and failing to show up to your hearing is not a good sign of cooperation. She then also, in one of her pleadings, did a movie review of The Black Swan. Now, I love to watch movies, and I love to look at movie reviews, right? But I am thinking a legal pleading, probably not the best place to do a movie review unless it's of My Cousin Vinny. Well, then I guess maybe that might be applicable, but come on, that's not exactly what you should be doing with your pleadings. So she's kind of making a mockery, if you will, of the whole process. And so the actual outcome was disbarment. Yes, she had received a 2-year disbarment for. Now, it wasn't because of the Photoshop pictures, though that started the process. It was her utter failure to cooperate in the process, and her failing to show up to hearings, things like that, that ended up in her being disbarred. So, all right. Moving on here to our next deal or no deal. I was doing this class in Pittsburgh, Pennsylvania. And they said, Joel, you've got to check out this local attorney here. You're not going to believe it. It is amazing. And apparently his office was just down the street from where we were located. I Googled it, and yes, sure enough, the ABA Law Journal wrote a story on this ad. It is going to amaze you as well. I am just sure of it. If for some reason this does not play as well through this webinar, I do encourage you afterwards, Google it. You'll find it online. It is hilarious and very thought-provoking. So let's watch this ad, and then we'll unpack it. This is Thanks, Dan.
Thanks, Dan. Thanks, Dan.
Thanks, Dan.
Thanks, Dan. Thanks, Dan. Thanks, Dan.
Thanks, Dan.
Thanks, Dan. Consequences. They sure suck, don't they? America was built on freedom, not on a bunch of people with more money than you telling you what you can and can't do with all their stupid laws. Laws are arbitrary. Hi, my name is Daniel Music, and I'm a criminal defense attorney based in Pittsburgh, Pennsylvania, and I stand ready, willing, able, and committed to defend you on all manner of criminal charges, including murder, arson, burglary, bank robbery,
simple and aggravated assault, and possibly even funny throwback crimes such as moonshining or pickpocketing. When you're charged with a serious criminal offense, you're facing the fight of your life. You need a lawyer who understands you and understands where you're coming from. Trust me, I may have a law degree, but I think like a criminal. Street knowledge. A lot of criminal defense attorneys around town are going to take your money and then blow you off. That's not me. I pick up the phone, I answer calls, I return letters, and I make jail visits, because I'll probably be there visiting my friends anyways. I'm the Pittsburgh criminal defense attorney Pittsburgh criminals hire when they commit crimes. I'm also licensed to practice in every single county in the Commonwealth, so don't feel left out, people in Beaver, Mercer, Crawford, Venango, or even Lehigh County. I'll go anywhere. Any criminal defense attorney who promises you a result is most likely a liar or a scumbag. But what I can promise you is my committed fighting effort to ensure that you are adequately defended on any charge that you're facing. Pay me now, thank me later. And remember, you keep your trap shut, and I'll keep your trap open. Did I mention I'm Jewish?
What does that have to do with anything? Did I mention that I am Jewish? Well, again, I hope that you were able to see that. That definitely shocked me the first time I saw that ad. I'm thinking, what is this horrible? This is crazy. This guy took every bad, negative lawyer stereotype out there, put it on a checklist, and then not covered them all. He went through that one, didn't miss a single one. Every bad, negative lawyer stereotype out there, that guy's it. But does it violate the model rules? Not so fast, because he did say that can't guarantee any results. That's a good thing, right? That's one of the ways that you can mislead people by guaranteeing results. And here he flat out said, can't do it. Anyone that does is a liar or a scumbag, possibly both. And so that's good. But something about that just seems wrong, right? How about the fact that it says crimes committed, and they're saying thanks Dan as they're committing those crimes? Just something about that is unseemly. Well, here's my theory. I think that under Rule 7.1, you cannot advertise services that you cannot provide. Under Rule 1.1 and 1.2, you cannot use your law license to counsel people how to commit crimes and fraud. And is that not what he is doing there? He is openly advertising to being the consigliere for the mafia. I want to be general counsel for your criminal enterprise. Did you catch that last line? Not the one about him being Jewish, the one right before that where he said, you keep your trap shut and I'm going to keep your trap open. Did you know what that meant? Well, I missed the first several times I saw this ad. I had to have a Philadelphia class, ironically enough, explain what that means. And it means this: trap has a double meaning. Trap means your mouth, so you keep your mouth shut. It's also urban slang for drug house. So you keep your mouth shut. I'm going to keep your drug house open. And so how is he not openly auditioning to be the consigliere for the mafia there? That's my theory. And so my offer is a public reprimand and take the ad down. Would you take it? Well, you're thinking, if I were Dan, I probably would not take this. It doesn't seem like he's going to take anything. But nonetheless, the actual outcome of the case was no charges were filed. And I was recently in Philadelphia and had a chance to look over the rules again. And no charges have been filed against this guy. And upon further review, I guess that makes some sense, right? I mean, after all, he's not guaranteeing results. He is saying that, look, if you are charged with a crime, I'm going to go after them. I'm going to zealously represent you. But there is a difference between counseling people on criminal matters retrospectively as opposed to prospectively. You cannot counsel people on how to commit crimes in the future, so here's how you can do them better to avoid getting caught. That you cannot do. But here, zealously representing them after the fact, well, not only can you do that, you are required to do that. That is your job. So that's why the ABA Law Journal wrote that story saying, finally, a lawyer tells the truth. It might not be that appetizing to hear, but nonetheless, that is an ethical requirement on our part to zealously represent our clients. All right, let's go here to this next one. This one is going to be a lawyer in Florida, and if you practice in divorce law, well, you might want to get some ideas here on how you can advertise your services. For the rest of us, we are going to learn how not to mislead with our legal ads.
Hi, I'm Steve Miller. I've been a trial lawyer in Florida and Massachusetts since 1985. If you and your spouse hate each other like poison and want to get out of the hellhole you call a marriage, you've come to the right place. Look, you can waste your money screwing around with some paper pusher paralegal type, give thousands of dollars to some piece of crap three-piece suit downtown, blow your brains out trying to figure out why you wasted $25 on the crappy forms you bought from the illiterate boob at the courthouse, or do what I say and do it now. We know what we're doing here. Look at this website, a work of art. Here's the story. Pay us a little and we get you a lot. Don't worry about the details. We'll take care of business and let you know when to crack open the champagne. Okay, time to move on. Go to the Get the Divorce page in the upper right corner, pay up, and you're on your way to getting rid of that vermin you call a spouse. We're here to help. Divorce Easy, a Florida law firm.
All right, Divorce Easy, a Florida law firm. My goodness. Well, first of all, here's a question I have for you. Do you think the guy is still married? What do you think? Is he still married? He has some pretty choice words to say about the institution of marriage. So I did a rewind, and sure enough, there's his wedding ring. That guy is still married. That's probably a pretty interesting conversation when he got home with his wife. After she saw it for the first time, she probably told him, you can keep yourself on that side of the hellhole. I'm the vermin you called a spouse, remember? Well, nonetheless, also, you might not want to ever hire him to write your Valentine's Day card or anniversary card. Mr. Romance, clearly this guy is not that. But nonetheless, let's look at his ad. Is it misleading? Did it mislead you as to the services that he can provide? And so my offer is going to be to take the ad down, because I maintain that it is misleading. And here's one way I thought it was misleading. Did he guarantee a result? Well, no. I mean, he did say that you pay us a little and we'll get you a lot. To me, that was misleading. I mean, I finished that thought probably the first 20 times I watched this video. Under the last antecedent rule, you pay with money. So when he says you pay us a little, gee, your mind is thinking of money, cash register sounds. So you pay us a little, we'll get you a lot. A lot of what? A lot of money. That's how you finish that thought. It wasn't a lot of divorce. That makes no sense. And so I finished it with a lot of money, and you cannot guarantee a monetary result. You probably could guarantee effectuating a divorce. If you can't effectuate a divorce for your client, then get out of law, right? That's clearly something under the law anyone can do, unless you're in South Carolina, I guess. But nonetheless, outside of South Carolina, it's a pretty simple process. But nonetheless, outside, you cannot guarantee monetary results. Now, he was given a letter from his disciplinary authority, and they said this ad was misleading, but not for the reasons that I said. Instead, it was because of this. His name was misleading. Divorce Easy misleads people. You hear that name, you think, wow, he can guarantee that the process will be simple, and you can't do that. It takes two sides to tango in litigation, and yes, I guess you can do what you can control on your side, but there's two sides to the litigation aisle, and the other side might be, experts making mountains out of molehills, blowing everything out of proportion. Yeah, that's not going to be a simple case, and so they asked him to change his name, so he changed it to Divorce Deli. So like you order a pastrami on rye, you can order your divorce tailor-made it to your liking with a choice of custody on the side. So there you go. That is Divorce Easy. Which brings me up to my last. It might be time to get a new lawyer quote here. If you wait to see your lawyer until you find his coupon in a local newspaper, well, then it might be time to get a new lawyer. Yeah, you don't want your lawyer running double discount coupon days. It's not a good look. Also, you're looking for a LASIK eye surgeon. That same rule applies. You don't want to have someone pointing a laser beam into your pupils who runs coupon days. But nonetheless, let us move on here to our next Deal or No Deal. And by the way, in saying that, I am serious that if you have any ideas on that regard, it might be time to get a new lawyer. We're talking about ethical violations, so it makes sense. We don't want to do these violations that would cause people to want to get a new lawyer. But if you have any funny ideas, again, go to our Facebook page and post them. We'd love to hear from you. All right, this next attorney we're going to go to. Yes, we're going to go to this attorney in Las Vegas, and this is going to be our last Deal or No Deal. This particular morning, well, it was not one of his better mornings. In fact, looking back on his life, this was a pivotal time. His life changed from this point on, and so he did not have a good morning. Things did not look right, and so the judge, well, that judge is going to have a few questions for him. Here you go.
The record will reflect that this hearing is taking place outside the presence of the jury panel. Defendant is here. He's in custody. Mr. Caramango, I want to address you first because it's my understanding you might have some problems this morning.
Judge, I was heading east on Sahara Drive, and I was rear-ended, and my car was undrivable. A good Samaritan drove me to the courthouse.
Who? Just someone picked you up and drove you here?
A good Samaritan, who's a Las Vegas local, drove me to the courthouse. And his name is Chris, and I apologize, Your Honor. I left my house at 9 o'clock this morning, and I was rear-ended. The person who hit me took off.
All right, so again, it was not a good morning for him. The person that hit him took off there, and so now there's a couple things I want to bring up to your attention. He mentioned that he was involved in a hit-and-run accident, and a person, a good Samaritan, took him to court whose name was Chris and was a guy. Again, file all those facts in the back of your mind. We're going to revisit those here in just a bit before we get done with this guy's story, but you just file those away. All right, well, again, things don't look quite right. He looks a little bit disheveled, so the court's going to be a little bit curious as to his appearance.
And
hit and run.
It's a hit and run, Your Honor.
You called the police, obviously.
I did not, Your Honor. I'm not in favor of dialing 911. So.
Even when you're the victim of a hit and run?
Philosophically, Judge, I never called the police.
All right, apparently, there's an ancient philosophy that goes something like this. When one is sauced up with liquor, one wants to avoid any and all confrontation with law enforcement. Yeah, I don't think that's a Buddha philosophy. I'm sure someone said it in the past. I guess you can kind of see the logic there. And so he's just following this ancient philosophy of not calling the police. By the way, how could you not be a fan of 911? Is there really a Facebook page, a Facebook group of 911 haters? Oh, I hate to call 911. I'm not a big fan. I didn't even know that was a thing, to not be a fan of 911. Nonetheless, I'm sure this judge is kind of her curiosity is perked up now, and so he's just getting going.
It's a pretty hard hit, and
right, because you don't look. I'm going to tell you, be honest with you, you don't look right this morning. That's why I'm concerned.
Judge, my neck and my back is killing me, but I'm ready to go forward.
Really, you're ready to go forward. Your neck and back is killing you. Dude, you can't get your subject verb tense correct. There is no way you're going to go forward. You're ready to go forward when you can't even get your subject and verb tense correct. So I don't think so. Just sit down and think about what you said. Well, nonetheless, that's how my English teacher would have responded to him. But how did the court respond to his statement that he was ready to go forward?
You don't think you need medical attention?
I think I do. Your Honor. But
okay, well, how about I have the courthouse nurse at least come up and take a look at you?
Judge, I'm willing to play hurt.
Pardon?
I'm willing to play hurt.
Well, the only problem with that is that sometimes that creates problems in trials.
I understand.
I'm not willing to play hurt. I want to be 100%. Because that's not fair to you. And it's not fair to your client if you're not 100%. And I'm telling you, my observations of you
I may have suffered a concussion, Your Honor.
Then for sure. Do you think you hit your head?
Judge, I know I had serious whiplash, and the driver that hit me took off, but I feel like I'm able to go forward.
And you feel like you suffered a concussion?
Yes, Your Honor.
Because you hit your head?
Because of the whiplash, Your Honor. I've had multiple concussions before, and I feel like I may have suffered another concussion.
I've had multiple concussions.
Yes, Your Honor.
Because...
I played professional ice hockey and I also played college football.
Okay, so you know what it feels like.
Yeah, my head has been the subject of many severe contacts, but I feel like I can go forward.
Okay, well, you just made a real great record for ineffective assistance of counsel.
I don't mean to make...
You know what? Can I just see everybody back in chambers?
I mean, he was busted. His whole philosophy is not ready to be busted, by the way. Isn't it kind of interesting to think about this case from the perspective of the different players, the different parties here? I mean, what is the client thinking? The client is sitting right there looking at his attorney thinking, am I paying full price? Did I get a multiple head wound, a discount here, multiple concussion, a discount? I thought I was paying for a full deck here. But yeah, nonetheless, it is interesting to hear your attorney stand up there and say he had multiple head wounds and concussions and severe violation, trauma to the head. But hey, I'm ready to go forward and represent this guy's case. Well, nonetheless, his whole philosophy is about ready to be busted. We see he had been taking this philosophy that he wanted to avoid any and all confrontation with law enforcement. That's why he's not a big fan of 911. He did not call police officers out there to the scene. And he's also saying, well, I'm going to go to court, and the judge is going to be way up there on the stand. I'm going to be at counsel's table. She won't be able to really see me that close. I'll get away with this. Well, his philosophy was busted because now she wanted to see him back in her chambers. They're going to be up close and personal. The bloodshot eyes, it's going to be much more obvious there in the back in her chambers. And so now the record does not show or reflect what happens next. So I'm just guessing a little bit. But I'm guessing she probably is obvious that he was drunk. So she thought, well, what do I do? So she goes to her policy manual, looks up the how to handle, what is the policy on a drunk defense attorney? There probably wasn't a specific policy on that. She went back in her index, you got depositions, we got discovery, no drunk attorney section here. And so let's say she called the chief, and the chief said, well, what do I do? He goes, what evidence do you have that this guy is drunk? Well, he looks drunk, his speech is slurred, he kind of looks like a drunk guy would look coming out of a bar. And no, that's anecdotal evidence. We need some hard, specific evidence if we're going to nail this guy. So go back and get some specific evidence to nail this guy. And so there he is, standing right behind him is, yes, a police officer. They're going to want him to blow.
Then we'll deal with it. Okay? Because trust me, we'll just deal with it. I have no desire to ruin your reputation or anything. We'll deal with it. I'll give you an opportunity to get it together. But at this point, I got Mr. Jacob Tunis, who is facing a life sentence.
Your Honor,
okay?
We're of that.
So if you came to court intoxicated, you have a problem. Do you understand me?
Your Honor, I can represent as an officer of the court. I am not intoxicated.
No. That's not going to work, right? If you are drunk, you can't represent anything. That's one of the problems of being drunk, right? It's kind of hard to keep your story straight, which, by the way, is one of the rules we were talking about, 3.3, candor and honesty towards the tribunal. Kind of hard to follow that rule when you are slightly inebriated. And so as this next clip is going to show, his story changed just a bit.
You represent me anything so far. So
I apologize about the misrepresentation about the evidence.
Josephine's name was Christine. She was your ex-girlfriend. Turns out you only knew her for 20 minutes. You said you were rear-ended. Your car has absolutely no rear-end damage. has substantial finite damage. It's not even registered to you. It's registered to a person who's incarcerated in the Nevada Department of Corrections. I'm not quite sure it can get much worse. So you just go ahead and blow. Let's get it over with. But let me tell you, my desire will not be to hurt you. It will be to help you.
Yeah, remember earlier when I said to keep in mind those different facts? So like a guy named Chris took him to a Samaritan took him to the court and whatnot. Yeah, no, his story changed a little bit by the ending there. It wasn't it was Josephine, not Christine. It was a girl, not a guy. He said it's my ex-girlfriend. Turns out he only knew her for about 20 minutes. It wasn't a rear-end collision. I mean, what's going on here? Why can't he get his story straight? And so I gave this class, and one of the ladies in attendance was from Las Vegas, and so she knew all those players there. And she said, Joel, did you catch what was going on? I said, no, what do you mean? You got a drunk attorney in court. No, something else, a little bit more salacious in details. Like, I'm not following you. What do you mean talking about? She said, yeah. Ex-girlfriend only knew her for 20 minutes. Kennedy doesn't even know her name. He had brought his hooker with him to court that morning. That's why he did not know her name. And that was the Good Samaritan that gave him the ride. And so apparently that is what, again, he cannot recognize a good decision if it slapped him in the face from a special prosecutor. All right, well, moving on here. Of course, going to have a few more questions about his appearance, wanting him to blow.
My only desire will be to help you and to make sure that this gentleman who's sitting at this table, he's facing a life sentence. Okay?
Your Honor,
He's facing a life sentence.
Your Honor, I've been an attorney for 16 years. I've had 67 jury trials. I would in no way jeopardize my client's future by not being.
Then just blow, so I can be.
Your Honor,
Just blow, so I can be confident.
I don't see the probable cause for me to blow.
All right, I don't know what law school you went to, but I can pretty much assure, I can say this with some confidence, that they never taught you to use that line in court, right? In your trial advocacy class, they did not cover the attorney using the line, Your Honor, you don't have probable cause to ask me that question. If that's what's happening and your day is not going too well, right? Somewhere along the way, if now the judge is asking you questions about your involvement, and once you're talking about probable cause, that's an indication your day is not going too well. By the way, this next clip, we're going to see another good indication of when your day is not going too well.
Repeatedly, so go ahead and blow. I absolutely am more than you. And there's a complete record, so if you're not happy with what I've asked you to do, then you have a remedy. You can take me to the Supreme Court.
I have respect and honor for Your Honor. And Your Honor's treated me fairly since the inception of this case. You've given me a fair trial this far.
Well, it's not you I'm worried about, it's Mr. Johnson.
You see, again, that is another good example, a good indicator when your day is not going too well. See, he came to court that day, sat at counsel's seat, and somewhere along the way he shifted over one to the left, and now he is in the defendant's seat. Not a good shift to occur for a lawyer. That is a day gone very, very astray. So, all right.
You want to show me? You got a good enough read? Okay.
1052, Your Honor. It's residual from last night. I am stone sober.
Mr. Caramango, if I was you, I would just be quiet at this
sorry.
point. Okay? Now, is it done?
Yeah.
All right, no, I have never been given I've never blown like that before, and so I had a DUI test done like that. But I have been told by the experts who have that is not a good sign. No, when they keep saying still climbing, that's not a good sign for you. And so let's see where it ended up.
Okay, for the record, your blood alcohol is a .075. And, well, will you state your name for the record? And you were ordered to come up here by myself, is that correct?
That's correct.
And you used to do these tests for me?
All right, again, so .075, and this is at, you can see, 1:45 in the afternoon. Now, he showed up in court that morning around 11 o'clock, got in his car to drive at 9 o'clock. And so, again, those that are in the know, tell me that if it was a .075 at 1:45 in the afternoon, it very well was a .12, .13 that morning when he was driving when he got to court. So yeah, he had a little bit to drink.
That may be an overstatement, Your Honor. I admit that I did have drinks last night, and I lost my grandmother about 2 weeks ago. And I've been under a lot of pressure. I wanted the best for my client, and it was a mistake to drink last night. And I apologize, Your Honor. And I don't know what else to say. I just.
All right, so he's trying to get a little bit of sympathy from the court, saying that he lost his grandmother 2 weeks ago, and so he should, the court should extend him some sympathy. Well, hold on to that thought here. Let's see it develop.
I hope you didn't have. I hope you weren't involved.
Your Honor, I said that I did the shots at the kill last night, Your Honor. I was in my office till 4 in the morning last night, and I did drink when I got home. I was stressed. I lost my grandmother a month ago. I lost my brother a night behind.
You said 2 weeks ago, now you said a month, okay?
So yeah, well, come on, Judge, come on. It's hard to keep the details straight when you are drunk, and so cut me a little bit of slack. That's why it's hard to remember these details, and so yeah, it's not a good day when you're trying to be straight with the court, but you are inebriated. It's just not going to go well for you.
I hope there's no reports of hit and run. I hope you weren't involved in a hit and run.
Oh, there's not, Your Honor.
I
did speak with the gentleman who hit me, and he took off.
Did you just catch that? He spoke with the gentleman that hit him before he left. Apparently, I do not understand what it means to be involved in a hit and run. See, I always thought it meant that someone hit you and then ran. That's where you get the run part on the hit and run. Not that you exchange pleasantries and, hey, say hi to the family for me, right? Say hi to the missus. How are the kids doing? All right, I'll see you later. No, that's not how hit and run works. Apparently, things are done a little bit differently there in Vegas.
To protect, I don't know, I've never had an attorney. Maybe the state can enlighten me. My only desire at this point is to protect Mr. Jakachunas. I cannot absolutely allow an attorney to proceed.
All right, now did you buy that? She kept saying, look, I'm here to help you, not hurt you. Do you buy that? I mean, the judge is wanting him to blow, admit that he came to court drunk, and she's, I'm not here to hurt you, I'm here to help you. I got to tell you, the first several times I watched this clip, I wasn't buying it. I thought, no, the judge wants to nail him. He's one who had the audacity to come into her court drunk, and so she's going to let him have it. But then I started doing a little bit more research and talking to a little bit more people and realized, oh, no, I think the judge actually was square on this one and was dealing with him straight up because she was looking after his best interest. You see, apparently, drinking alcohol is a very serious problem for attorneys. The American Bar Association just did a study where they concluded that attorneys are 3 times as likely to suffer from alcoholism than the general population. We're twice as likely as other professions like surgeons to suffer from alcoholism. There is something about the legal practice driving us to a drink. Now, we're all attorneys, so we pretty much know, yeah, we saw that one coming. That does not come as a surprise to us. We have experienced the pressures and the demands that come with the legal practice. We see the prevalence of alcohol that runs through the legal circles, you know, the law firms. When I worked at a law firm, it seemed like every single day the big discussion was, we're going to do happy hour today, right? And so that was the big deal. Well, again, here's what the bars want us to know. Now, when I say bars, make sure we're on the same page. The bar associations. I'm not talking about the bars that serve the drinks, but what the bar associations want us to know is there is help for you. And so it's an anonymous call. All you have to, if you see some alcohol tendencies in your personality, in your life, and by the way, you go to the ABA's website, just Google ABA symptoms of alcoholism. The list is right there. You can read it, and you'll find an interesting observation that I discovered when I went there and downloaded it. I realized if you took out alcohol and replaced it with coffee, I fit every single one of those descriptions. You get irritable. You got to have it at a certain time of day. It's costly. You ever been to Starbucks and bought a cup of coffee? But it seems like if you were to replace alcohol with coffee, the symptoms are right there. But nonetheless, if you see symptoms of alcoholism in your life, it's an anonymous call. Call the attorney hotline. You can get help. And yes, technically you'd be incompetent to handle your legal work. But if you are getting help for your alcoholism, no one has to know about it, and you will be fine. Or if your career crashes, I think we all can agree that showing up in court drunk, that's an example of your career crashing, especially when the videotape is running. Not going to be a good day for you. Still, don't worry about it. There's going to be help for you. As long as you go get help, yes, you will have to suffer a little bit of a discipline for allowing your career to crash. That's all fair. But nonetheless, as long as you are getting treatment, things will be fine, but you need to be getting a treatment. That is the point there. And so the deal I'm going to offer you in our last deal or no deal is a 1-year suspension and to get help. Would have been very wise to take it. This person did not take it, and so he was disbarred. So there you go. That is our deal or no deal. Thank you so much for attending today. I had a lot of fun sharing these stories with you. Again, I'm going through all these examples and reading these cases of lawyers getting themselves in trouble. You do realize that sometimes they get themselves in trouble for the smallest of things, and sometimes it's the biggest of things. But nonetheless, I guess it's our job to learn as we go about so that we do not go and do likewise. Thank you so much for attending, and see you next time.